Alicia Daniel Hall, Florida estate planning probate attorney and realtor. If this is your first time visiting my channel, welcome, and please don't forget to like and subscribe so that you can be notified as soon as I upload new videos about estate planning, probate, or real estate. In this video, I am going to review how to sell probate real estate in the state of Florida. Possible to sell real estate during the probate process. So you don't have to wait until after the probate is complete in order to sell it. It just means you're going to have to go through additional steps in order to get there. The first step is you have to actually open the probate case. This means you have to have a personal representative appointed to administer the assets of the estate. Next, if there's a will, we have to take a look to the terms of the will and see what they say. For example, if the will specifically authorizes the personal representative to sell estate assets, technically you don't need a court order, but I always go ahead and get the court order just to make sure that everyone is covered and everyone has notice that we are going to sell the asset. If there is no will, then you're going to need a court order. Next, you need to find a licensed realtor who is authorized to sell real estate in the area where the property is located. Once a contract has been accepted by the personal representative, you will need to file a petition with the court asking the judge for permission to complete that sale. In Florida, we have a 90-day creditor period. That is 90 days from the date of first publication. If you are within the 90-day creditor period, then the proceeds from the sale are going to have to be held either in an attorney trust account or a restricted depository account. Those funds will not be dispersed until there is a court order authorizing the disbursement of those funds. I always recommend that any contracts involving probate property clearly state that the sale is subject to court approval. This will make sure that all parties involved, the buyers, the lenders, the title companies, and any attorney are all aware of the fact that there must be a court order in order to close on that transaction. And no one is surprised when they receive notice that we're not closing just yet because we don't have the order. And once the court enters an order authorizing the sale of that real estate, the parties can go ahead to the closing. Title companies and attorneys involved must make sure that they are following the terms of the court order. Specifically, if the court order says the funds need to be held in a trust account, those proceeds need to be wired accordingly. If the funds have to be held in a restricted depository, same thing. Again, it's very important that those proceeds go to where the court order requires they are sent. If you have recently lost a loved one who was a resident of or owned real estate in the state of Florida, and you need assistance with the probate process, please click on the link below to schedule your free probate consultation. Additionally, if you are interested in buying or selling probate property here in the state of Florida, feel free to click on the link below and we can discuss selling or purchasing that probate property.